The superpowers have united again and they're suing California over the new Glock ban. First, yesterday's video drew the attention of the Department of Justice. Good. In it, I criticized the self-proclaimed most 2A-friendly Department of Justice ever, saying that defending the NFA, the National Firearms Act, is not pro-2A, period. The Assistant U.S. Attorney General, Harmeet Dillon, didn't like the video, and she tweeted about it. But that's okay, because I don't like people taking advantage of or gaslighting the gun owners in this country, saying that they're fighting for the Second Amendment while defending unconstitutional infringements in court. Hard stop. So watch that video if you haven't already, and if you want more clarification of what I point out in the Department of Justice's response to a petition for writ of certiorari at the Supreme Court challenging the NFA. Let's get into this video. Hey everybody, welcome back to Guns and Gadgets, your premier source for Second Amendment news that you won't hear anywhere else. P.S. Don't trust the government. Get a shirt down below. They get them all the way up to 6X, I think. Now, we've got a major new lawsuit hitting California, and it's one that could have national implications for the Second Amendment and for millions of law-abiding gun owners across the country. The Second Amendment Foundation, Firearms Policy Coalition, and the National Rifle Association have teamed up, yeah, you heard that right. They've teamed up to sue the California Attorney General, Rob Bonta, over a brand new gun ban that specifically targets Glock handguns. That's right, California has officially decided that some of the most popular handguns in America, the same Glocks used by law enforcement, by military personnel, and by millions of responsible citizens, are now too dangerous for civilians to own. Let's break down exactly what's happening, what the lawsuit says, and why it could turn into one of the biggest 2A battles of 2026. Real quick, I want to thank our sponsor, CMMG, for always supporting this channel. If you believe in quality, precision, and protecting your rights, these folks are worth knowing. Whether you're looking for 22s, bigger chamberings, or just accessories done right with attention to detail, CMMG delivers, always. Their craftsmanship and respect for the Second Amendment show, and as always, purchasing from reliable manufacturers helps us ensure safety, accountability, and quality. G&G 10 will make you smile over there as well. Thanks to CMMG for supporting this kind of important conversation, whether or not I ruffle some feathers. I appreciate it, it really means a lot. Now, this lawsuit is officially titled Jaymes v. Bonta, and it was filed yesterday in the Southern District of California. And the plaintiffs include some individual gun owners, the Poway Weapons and Gear Range, and the three powerhouse gun rights organizations that I have already mentioned, SAF, FPC, and NRA. Now, their goal is to strike down what was formerly known as AB 1127, now known as California Penal Code Section 27595 Alpha, a brand new law that bans the sale or transfer of what the state calls semi-automatic machine gun convertible pistols. Now that might sound complicated, but let's unpack what it means in plain English. Under this new California law, which takes effect July 1st of 2026, licensed firearms dealers will be prohibited from selling or transferring any semi-automatic pistol that has a cruciform trigger bar and that the state claims could readily be converted into a machine gun by installing a part called a pistol converter. Now, if you're not familiar with that term, pistol converter, it's made up, but it's essentially a device that can turn a semi-automatic handgun into a machine gun, and for those who love grammar, the machine gun pistols. Think of the illegal auto-sear devices that we've seen ATF going after, or the Glock switch, or items similar to that. You know, those things that are already banned under both federal and state law. So what California is doing here is not banning the converter itself, because it's already illegal. They're banning the guns that could theoretically accept one. And which guns are those? Glocks. Pretty much all Glock pistols and any Glock style or Glock pattern handgun with that same cruciform trigger bar design. The state calls them machine gun convertible pistols. The plaintiffs and millions of gun owners call them the most popular self-defense handguns in America. And here's where this becomes absolutely insane. The lawsuit points out that these Glock pistols are in common use across the entire country, including California. The Supreme Court has already said that firearms in common use for lawful purposes are constitutionally protected. In District of Columbia versus Heller, the court made it crystal clear handguns are the quintessential self-defense weapon and the most popular weapon chosen by Americans for self-defense in the home. That means that any ban on a popular category of handgun is unconstitutional, full stop. But California never got that memo. And let's see if the most pro-2A DOJ in history has anything to say about this either, because I bet they don't. But even after a federal court already ruled in Rob Bonta that parts of the state's handgun restrictions were likely unconstitutional, the legislature decided to double down. Instead of learning their lesson, they've now expanded their ban to target even more popular handguns designed for self-defense. And according to the complaint, this law, Assembly Bill 1127, was signed into law by Governor Gavin Newsom on October 10th, 2025, and I covered that in a video as well. It makes it a crime for a dealer to sell, offer for sale, exchange, give, transfer, or deliver any pistol that falls under the new definition. And violations could result in fines or the loss of the dealer's license. And that's exactly why Poway Weapons and Gear, one of the largest ranges and gun shops in Southern California, joined the lawsuit. They've sold thousands of these handguns over the years, all perfectly legal. But starting next summer, July 1st, they'll be forced to stop, not because of any safety concern, but because of California's overreaching political agenda. Plaintiffs like Danielle Jaymes and John Phillips, along with thousands of other Californians, will be unable to purchase these handguns for self-defense. And that's not just an inconvenience, that's a constitutional violation. Under the Bruin decision, the Supreme Court laid out a very simple test. If a gun law restricts conduct protected by the Second Amendment, the government has to prove that the restriction is consistent with this nation's historical tradition of firearm regulation. So, unless California can show that there's a historical tradition of banning specific types of handguns simply because they could be modified, not that they are modified, then this law fails the Bruin test. And here's some behind-the-scenes secret info. Every gun can be modified. All of them. And spoiler alert, there's no such tradition. The lawsuit backs this up with hard data. In 2021 alone, Glock manufactured over 580,000 handguns in the United States, and more than 500,000 of those were sold right here in America. That doesn't even count the hundreds of thousands imported from Austria. These pistols are in police holsters, nightstands, glove boxes, and gun safes across every corner of this country, including California. They're used for home defense, concealed carry, and competitive shooting. And yet, California thinks that they can just declare them off limits. The complaint even points out that Massachusetts is the only other state dumb enough to ban certain pistols, mainly Glocks. And that tells you exactly how extreme California's position really is. They weren't even the first to do it. The plaintiffs argue that banning the sale of these pistols directly violates the Second and the 14th Amendments to the United States Constitution. The right to keep and bear arms naturally includes the right to acquire them, because if you can't buy one, then you can't own one, then you can't bear one. The Ninth Circuit itself confirmed this earlier this year in B&L Products versus Newsom, saying that if the right to acquire firearms isn't protected, then the right to keep and bear them would be meaningless. And California's new law takes that right and crushes it under the weight of bureaucratic paranoia. Here's the bottom line, folks. California is once again trying to outlaw freedom under the guise of safety. They're not targeting criminals, they're targeting you, the law-abiding citizens of the state of California, and they're banning the very tools that make self-defense possible, all while not taking it out of the hands of the bad guys. But this time, they've picked a fight with some of the biggest names in the Second Amendment movement. SAF, FPC, and NRA, all working together in one unified legal strike. Now, if this lawsuit succeeds, it won't just protect Californians. It'll set a precedent that could stop other states from trying to pull the same stunt in the future. Looking at you, Maura Healey over in Massachusetts. The Second Amendment doesn't end at California's borders, and it sure as hell doesn't bend to Rob Bonta's will. As always, I'll keep you updated every step of the way, and if you want to read the full Jaymes versus Bonta complaint, I'll link it down below. If you found this video helpful, hit the thumbs up, subscribe to the channel if you're new here, and share this with every gun owner that you know. And before we wrap up, a huge thanks to my title sponsors, Blackout Coffee, Attorneys on Retainer, and CMMG for always supporting this channel and the mission and the message to keep Americans informed and empowered, all brutally honest and unfiltered. It means a lot to me that y'all stand by the channel. Stay safe, stay informed, and stay armed. And most importantly, stay free, America. This is Jared from Guns and Gadgets, the premier source for Second Amendment news. And as always, be safe, stay vigilant, and carry a gun. Take care.